Hi, everyone. We're just seeing the numbers tick up here, so we'll just give it a couple more minutes for everybody to jump on. Let's see. All right. All right, still ticking up a little bit. Well, I'll get my part started since it's not quite as important as what Laura's going to talk about. So good afternoon, everyone. Welcome. Thanks so much for joining us today as we begin our three-part educational series on the intricacies of mass health. We're excited to kick off this series with today's session, which is just an introduction to mass health planning, which is the first in a lineup of informative discussions designed to help individuals and families better understand important aspects of mass health and long-term care planning. Over the next few months, we'll continue the series with Protecting Your Home from Estate Recovery, and that'll be in May, followed by Home Health Coverage under Mass Health, and that'll be in June. Each session is designed to provide practical guidance and valuable insight into topics that can have a significant impact on future planning decisions. It's now my pleasure to introduce Laura Goodman. She's a partner at Margolis Bloom D'Agostino, and she'll be leading today's presentation and guiding us through the topic. Laura brings a wealth of knowledge and experience, and we are grateful to have her share her expertise with all of us. We will have time for questions. So if you haven't used GoToMeeting before, you should see in the top right-hand corner, there is a little icon with a question mark in it. If you click there, you can enter your question. If it's a clarifying question while she's speaking, I'll be monitoring it and I'll interrupt her. If it's a bigger picture question, we'll wait till the end to see if we can address any of those. And just please note that we can't provide specific advice, only general information. So with that, please join me in welcoming Laura.
Thank you, Beth. All right, so as Beth mentioned, I'm Laura Goodman. I'm an attorney here at Margolis and Bloom. And in addition to the estate planning services that we provide, we also do a great deal of long-term care planning. And so this is the first of 3 series. I am going to be focusing on long-term care in a facility. So this is a nursing facility, skilled nursing facility. So there will be other opportunities to learn more about other types of mass health long-term care. So first slide here is, why are we talking about Medicaid planning? Just a point of clarification, Medicaid and Mass Health are synonymous in Massachusetts. So Mass Health is the Medicaid program that's administered in Massachusetts. So if you hear the terms, they're referring to the same thing. And the reason that we have to look at Medicaid or mass health planning in this context is that most of us are going to need some type of long-term care assistance during our later years. And the amount obviously varies depending on a person's particular needs. We also are on the precipice of the baby boomers entering their 80s and beyond. And so the oldest baby boomers are turning 80 this year. It's actually anticipated that the population of people age 80 and over are going to double between 2025 and 2045. So there's going to be a lot more discussions and need for long-term care in the future. So long-term care is actually not covered by Medicare. So Medicare is the federal health insurance program predominantly for seniors and also certain individuals who receive disability benefits. Medicare covers, Part A covers hospital services, Part B covers doctor's visits and other outpatient services. There's also parts for prescription drug coverage, there's supplemental coverage, but it does not cover chronic long-term care services. So Medicare may cover, or does cover rehabilitation care if it's medically necessary for a period of time. But if a person needs to reside in a long-term care facility for, assistance with their daily living, and they're not, improving or receiving medically necessary care, then that is not something that Medicare will cover. So that's why we often are looking to Medicaid as an option. Some individuals are fortunate to have good long-term care insurance policies in place. If that's the case, then they may already have some assistance paying for care if they need either in home or in a facility. We do see less and less of these long-term care insurance policies than were issued in the past. And it's very few people who can really afford to pay out of pocket for long-term care. The costs, if any of you have dealt with this with loved ones, the costs really can be astronomical, both for home care and for care in a facility. So what exactly is Medicaid? So traditionally, Medicaid is health insurance coverage for persons who have low income or have disabilities. These are the programs that you may hear referred to as MassHealth Standard. Common Health is also available for persons who meet the disability requirements. And then Medicaid also does cover long-term care for people who are both clinically and financially eligible. And often that financial eligibility is achieved after a spend down of resources, and we'll get into that today. So the long-term care benefits provided by MassHealth include care in a nursing facility, in a skilled nursing facility or a nursing home. It does cover some home care services, such as personal care attendance. There's something called commonly referred to as the frail elder waiver, or home and community-based waiver services, which provide certain types of services at home. We're not getting into that today. That's going to be addressed at the June webinar and Lunch and Learn. And in some limited cases, it can also provide a subsidy for assisted living care. Again, we'll address those particular benefits at a later date. So just before I start, I just want to address that the Medicaid or MassHealth rules are extremely nuanced. They vary state to state. So what I'm saying here for Massachusetts is not going to be applicable to your parents who live in Arizona. And we're going to do an overview of this and get into as much as we can, but we can't cover everything, and we can't cover all of the different exceptions and waivers and all of that. So bear with me on that, and happy to answer additional questions at the end as time allows. And when we talk about MassHealth Planning, we're going to address some advanced planning options, sometimes called a 5-year plan. But we're also going to address something that we refer to as crisis planning, where there was no advanced planning done in the past, and what are some strategies that can be used to try to preserve things. All right, so the first thing I want to address is the resource limit for long-term care benefits. So MassHealth benefits actually before you turn 65 generally do not have an asset limit. So if you're receiving MassHealth on account of your income or your disability status and you're under 65, MassHealth does not care what assets you have. However, once you turn 65, MassHealth does impose this asset limit. And also, if you're any age and you require care in a nursing facility, they're going to impose this type of limit. So for a single individual who needs care in a facility, the asset limit is $2,000 of countable assets. And we're going to get into what's countable and what's not. For a married couple, if one spouse needs care in a facility, the spouse at home is allowed to keep up to $162,600 in countable assets. And so that amount, that's called the community spouse resource allowance, that is adjusted each year. So that it recently was increased up to that 162-ish amount. If it's a married couple but both need care in a facility, they're going to both be subject to that limited $2,000 in countable assets. There really isn't an income limit for care in a facility. The person's income, the MassHealth applicant or member's income, is factored into what we call a patient pay amount, or PPA. It's sort of like a co-payment. So it's paid directly to the facility. So if they're getting $1,500 in Social Security benefits, plus $300 in pension, that's going to be used to calculate what amount they have to pay to the facility directly each month, and then MassHealth picks up the rest of the tab. And the spouse's income is irrelevant. So if the spouse at home is not applying for benefits, MassHealth doesn't care how much income they receive. All right, so what type of assets does MassHealth count? So as a general rule, any asset that either the MassHealth applicant or their spouse has that can be sold or liquidated or otherwise converted to cash is going to be countable as an asset. So that would include cash and bank accounts, checking and savings accounts, most retirement assets, so IRAs and 401ks. There is an exception for certain retirement plans. So for example, if the applicant's spouse is still working and contributing to a 401k, that 401k may not be countable as an asset. Other securities, life insurance, if the cash value exceeds $1,500, that's going to be countable as an asset. Real estate other than the principal residence. So I did see a question pop up asking if the principal residence or the home is factored into the amount of assets that a spouse is allowed to keep. And the answer is that your principal primary residence is going to be non-countable as an asset. If you own additional real estate, so if you have a Cape House too, that is something that's going to be considered a countable asset. Most annuities are going to be countable. There are very specific types of Medicaid compliant annuities that are exempt, and we are going to get into that a bit more. But in general, an annuity that doesn't meet those criteria is countable. If you have a revocable trust, so these are trusts that are commonly used in estate planning for probate avoidance. So if you have a trust where you're the trustee and the beneficiary, and you transferred your house or other assets into that for probate avoidance and estate planning purposes, that is going to be accessible and considered a countable asset for MassHealth. If you have an irrevocable trust, so this is another type of trust used in estate planning. If there's any circumstances under which you can receive the principal of that trust, that also is going to be a countable asset. We will get into irrevocable trusts and how they are successfully used how they can successfully be used to protect assets for MassHealth planning purposes. All right, so certain assets that are not countable. Sorry, I just wanted to make sure all right, so not all assets are going to be considered countable for the application process. So as I mentioned, the principal residence is not countable. The regulations say that if the equity in the house exceeds a certain amount, it's currently 1.13 million, then the value above that equity amount could be considered an accessible resource. That exception or that provision does not apply if the spouse resides there or if a disabled child resides there. So we don't see that a lot in practice. Also, if you have a prepaid funeral plan, those are exempt from MassHealth accountability. A primary car that's used either by the applicant or by a family member to help them get around to appointments or things like that is going to be exempt. As I mentioned, certain retirement plans will be exempt if the participant is still contributing to them. If you have very small cash value life insurance policies, so cash value under $1,500, that is not going to be considered a resource. You can also set aside up to $1,500 in a burial account. So in addition to a prepaid funeral plan, you can set aside some additional funds for burial purposes that will be considered exempt. There's an exemption for, it's called business property essential for self-support. So an example of this is if a family owns a commercial property that they rent out, and you know, this has been a pattern in practice for over a period of time. You may be able to exempt that property from accountability on the basis that it's the revenue generated by that property is essential to support, you know, the spouse, for example. So that sometimes it is sometimes that will be exempted. Of course, any income generated is, you know, going to be factored in and may be part of that patient and pay amount that the MassHealth member has to pay to the facility. Another category is legally inaccessible assets. So this is an asset that technically the MassHealth applicant or their spouse has an interest in, but they can't access it. So for example, if they are inheriting money from another family member, but it's tied up in probate and they can't access it yet. During that time when it's legally inaccessible, MassHealth won't count it. Of course, as soon as any legal obstacles are removed, that's something that is going to be accountable asset and would, you know, have to be spent down or otherwise dealt with. Another example that sometimes comes up is when individuals lose capacity and they can no one can access, you know, certain financial accounts in their name. So in a long-term care context, if the person needing care in the facility does not have, you know, capacity to manage a bank account, and there's no power of attorney or joint owner or someone else who can access that, you know, in that scenario, a conservator typically needs to be appointed by the probate court in order to grant someone access to, you know, be able to manage that account, spend down assets. So during that time before the conservator is appointed and has access, you know, that's another example of something being legally inaccessible. And again, it's only going to exempt the assets for that period of time. You can't, you know, rely on that to have them exempt in perpetuity. And then certain trust assets. So a common example that we will get into more is an irrevocable trust that is set up for the purpose of long-term care planning. Other types of trusts that may not be countable would be a third-party trust, meaning a trust that was set up not by the MassHealth applicant or their spouse, but maybe they received an inheritance from a parent or a family member in a third-party trust where they don't have, you know, control or discretion over the trust. Those types of trust assets may be exempt as well. All right, there were a couple questions that popped up, and both of these we're going to address later, so I'm going to hold off on answering those now. All right, so now that we generally know what assets are going to be countable and not countable, now we're going to talk a bit about what happens when you transfer assets. So at the time you submit a MassHealth application for benefits, for long-term care benefits, you need to report to MassHealth if you transferred any assets out of your name for less than fair market value within 5 years prior to applying. So unfortunately, you can't just, you know, move all of your assets to your children and then apply for MassHealth. That's not going to work, because they're going to look back 5 years and see that you transferred those assets. It's considered a disqualifying transfer if you gift or otherwise transfer assets for less than market value. And MassHealth will impose a penalty period on those transfers. So the way the penalty period is calculated, excuse me. Give me one moment. So the way the penalty period is calculated is you take the value of assets that were transferred and you divide it by the average monthly cost of nursing home care in the state. Oh, geez. So currently in Massachusetts, that average, there's an error in here, divided by the average daily cost, sorry about that, of nursing home care. So currently the average cost of nursing home is $450 per day. So an example here, sorry about this. If John Doe transferred $200,000 to his child, and then 3 years later, so we're still within that 5-year look back period, he applies for nursing home care. So you take the $200,000, you divide it by the $450 daily rate, and the result is 444 days of ineligibility. All right, so it's a little over a year that you would be ineligible to receive MassHealth nursing home care. So a common misconception about this is like, oh, well, it's been 3 years, so I'm beyond the ineligibility period. But no, the penalty period begins when John is in a nursing facility and is otherwise below the $2,000 asset limit. So it doesn't start when the transfer is made. It starts when he actually needs to apply for those Medicaid benefits. So until that penalty period is up, he would have to pay privately. And, so and if you've transferred your funds, you may not have the funds to do so. So what happens in those cases is if you don't have the funds to pay privately, you can cure the transfer. So basically his child can transfer the funds back to John, and then he can spend them down in a permissible way. Or if the family has the resources, they can pay out of pocket until that penalty period has expired. All right, so there are exceptions to the transfer penalty. The first is that assets can be transferred without penalty to your spouse. However, the spouse still needs to be within that community resource allowance of around $160,000. Assets can also be transferred to a permanently disabled child or to a trust for the sole benefit of a permanently disabled child. It can also be transferred to a trust that's established solely for the benefit of another individual, not necessarily a child who is under age 65 and disabled. Another exception is transfers to a pooled trust. So these are sometimes called the statutory reference is a D4C trust. So a pooled trust is managed by a nonprofit organization. There are a number in Massachusetts, and essentially you contribute your assets to this pooled trust, and the pooled trust company, the nonprofit organization, manages the funds and manages any distributions from them. One drawback, so to speak, to this type of trust is that there's a Medicaid payback provision in it, which means that if you do contribute your assets to that trust to qualify for MassHealth, upon your passing, the state can recoup money from the trust to repay itself for any MassHealth benefits it provided. In many states, you have to be under 65 in order to contribute to a pooled trust. In Massachusetts, currently, you can be over 65 and do that. There was a period of time where we thought it was going to be going below 65 again. But fortunately, currently, the rules allow pooled trust transfers over age 65. And the other transfer penalty exception, which is a bit more limited, is you can, purchase burial accounts, prepaid burial plans, and that is not going to be subject to a penalty. So there's some additional penalty exceptions for the home, for the primary residence. And we know that it can be transferred to the spouse, and it can be transferred to a child, either who is under age 21 or who is permanently disabled. Also, if you have a sibling who has an equity interest in the house, so that means if a sibling is a joint or co-owner of the house, and if the sibling has resided there for at least 1 year prior to the person entering the nursing facility, they can transfer the house to that sibling, and that's not going to be subject to the transfer penalty. And so that's useful in situations where it's a family home that was inherited by multiple siblings who live there together. So that offers some additional protection. Another exception, which is used fairly commonly, is what we call the caretaker child exception. So this is if you have a child who is residing in the primary home for at least 2 years prior to the parent entering the nursing facility. And if the child provided care to that parent that allowed them to remain at home, then the parent can transfer the house to the child under this exemption. And so this is to, basically reflect family caregivers providing services. It can't be, you can't just have the child move in and, kind of just help out around the house for a few months. You do have to establish that they have been living there full time for at least 2 years prior to the parent going to the facility. All right, so we know that you can transfer assets to the spouse without penalty. And you actually have up to 90 days after being approved for MassHealth to shift any remaining assets into the spouse's name. So, it's common that we would submit the application for MassHealth benefits while assets are still jointly held between husband and wife, and then or spouse and spouse, sorry. And then once the approval is received, you have up to 90 days to complete the process of moving assets out of the nursing facility spouse's name into the community spouse's name. And just reiterating the current asset limit for the spouse at home, which is around $162,000. There, in some special circumstances, we can appeal to get an increase in that $162,000 resource allowance. So the circumstances where this can be permitted is if the spouse at home or in the community has medical needs of their own and has significant medical costs, and if the assets that they're allowed to keep would not generate enough income to be able to support those medical costs, then you can submit a request to the Board of Hearings to increase that spousal allowance. And that process does take a lot of time because you have to go through the whole MassHealth application and then do an appeal to the Board of Hearings. But it can be a really, really great result for, if the family meets those criteria. So some additional ways to protect the primary residence. A lot of long-term care planning centers around trying to protect the home and trying to, pass the home on to future generations. So in the situation where one spouse is in a nursing home, one spouse is, at home or in the community, we would pretty much always recommend that the house be transferred 100% into the name of the spouse who's still at home. And in conjunction with doing that, we recommend that the spouse who is at home creates a new will, which includes something called a testamentary trust. So this is a really special type of planning strategy. So basically, these are special types of trusts that are created under a will itself. It's not a revocable trust or an irrevocable trust. This is a trust that the terms are within the will itself. And these types of trusts are not considered countable resources under the MassHealth rules. So the way it works is that if the spouse at home dies first, then the house or any other assets in that spouse's name go into this testamentary trust and will be protected for the spouse who's in the institution for the remainder of their life. And it's not subject to any 5-year look back, and it doesn't have to be spent down in order for the spouse in the facility to continue receiving benefits. So we pretty much always recommend that for the spouse at home, just in case they were to pass away first. So a quick note on state recovery. We're not going to get into the details of this because this is going to be addressed next month. But state Medicaid programs like MassHealth are required to recover costs from Medicaid beneficiaries who pass away. So if you are over age 55 and receiving Medicaid benefits, then the state, is going to have an estate recovery claim against your probate estate. If you're any age and receiving care in a long-term care facility, then your probate estate is going to be subject to this estate recovery. So the recovery is limited to your probate estate. And what that means is assets that are in your individual name when you pass away that don't have a beneficiary or a joint owner. There's a waiver for small estates. So if you are eligible for something called a voluntary administration, this is where your probate assets are under $25,000, not including the value of a car. MassHealth is not going to pursue a estate recovery claim against those estates. But even if an asset is not considered a countable asset, so in the for example your primary home, or if it's you get the business property essential for self-support exemption, those are still assets that are in your probate estate, so that would still be subject to estate recovery. So there are some strategies to both protect the primary residence from accountability and avoid an estate recovery lien upon the MassHealth member's passing. So a very common planning strategy is using an irrevocable trust. And this is a trust where I'm trying to decide what level of detail to provide in terms of explaining trust. But so an irrevocable trust essentially is a trust agreement that's created by the grantor. The grantor is the person who creates and funds the trust. That grantor is going to have to give up some level of control over the assets they put in the trust, because they cannot serve as trustee, and they are not they're not a principal beneficiary of the trust. So really the purpose of this trust is to preserve assets for children or other family members. Setting up this type of trust and transferring assets into it is subject to a 5-year look back period. So if you create an irrevocable trust, put your home in it, for the next 5 years, you're not going to be able to apply for Medicaid, because the penalty period will apply. So you need to make sure that you have enough resources outside of the house to be able to cover those costs. If it's anticipated you would need nursing home care within 5 years. Once the house is in the irrevocable trust, you can't access the equity in it. So, if your plan is to, take out a reverse mortgage or, take out equity to pay for care, that's not going to be possible with an irrevocable trust. It's very important that if you are considering this, that you work with an elder law attorney who has experience in long-term care planning. A good indicator of that is if they're a member of NALA, which is the National Academy of Elder Law Attorneys, because you want to make sure that this trust is drafted properly. And a properly drafted trust typically would include the right for the individual to remain living in the property and use the property for their lifetime. Would also want to see language in there that allows them to benefit from the residential capital gains exclusion if they were to sell the property while they're living. So that's, if you own and reside in your primary residence, you can exempt up to $250,000 in capital gains when you sell the property. So we want to make sure that exemption is preserved, because it's very beneficial. We also want to see language in there that would allow the beneficiaries or the children of the trust creator to receive a step up in the tax basis of those assets when the grantor passes away. Another feature of these trusts is that they do avoid probate. And so because they avoid probate, it avoids estate recovery. So there's not going to be any lien on this property. All right, another option, another fairly common option is called a life estate deed. So this is where you're not transferring the property to a trust, but if you own the property, you can transfer it to your children, for example, but retain a life estate, which means that while you're living, you retain the right to live on the property, use the property, you're responsible for the expenses, but upon your passing, your children or whoever you have designated as the remainder beneficiaries, they automatically inherit the property. And this again is subject to that 5-year look back period, because you are giving away the remainder interest in the property, which has a value. And this option is best when it's not anticipated the property will be sold while the parent is still living. And that's because if it's decided that the property does need to be sold, one, the parent doesn't have that ability to sell it themselves. They would need the consent of the remainder men. So whoever they've granted that remainder interest to would have to agree to sell it. And also, if it's sold while the parent is living, they're only going to get a portion of the capital gains exemption, only that amount that is part of what their life estate value is calculated at. Because since they gave away the remainder interest, they don't own a full 100% interest in the property. They only own what their life estate is valued at. And there's IRS tables that you use to calculate what that amount is. So if it's anticipated that the house will not be sold until after the parent passes away, this can be a okay option. It does avoid probate, which means it avoids any type of Medicaid lien. It does get a step up in the tax basis when the parent passes away. So it does have those elements. It's just not as flexible as an irrevocable trust, particularly if a sale in the future is anticipated. All right, so those two options, both the irrevocable trust and the life estate, those are advanced planning options or 5-year plans, because in order to get the protection for Medicaid purposes, you need to take those steps at least 5 years before you would need to apply for benefits. So now I'm going to talk a little bit about some options for crisis planning. So this is the situation where mom and dad did no planning, and we're now at a place where one of them is in a rehab facility and needs to go into long-term care, and what can they do? So the first option is something I alluded to before, which is these Medicaid compliant annuities. So if you remember when we were talking about assets and income, the spouse at home is limited to the resource allowance, but MassHealth doesn't care how much income the spouse at home is receiving. So what we can do is basically the spouse can purchase an annuity, a very specific type of annuity, with the excess assets. So if they have $400,000 in assets, they're limited to 160. They can put those extra assets into this Medicaid compliant annuity, convert it from a lump sum into an income stream. So these annuities, they have to be irrevocable. They have to be for a set term. The other requirement of these annuities is that you have to name MassHealth or the Commonwealth of Massachusetts as the primary beneficiary on it if the annuitant dies before the annuity pays out. So you can get a fairly short term of an annuity, a few years. So hopefully the annuitant would survive that term, and there would be no need for the Commonwealth to collect on it. But that is a requirement for these annuities, that the Commonwealth has to be named beneficiary if the annuitant dies before it is paid out. Let's see. The type of annuities can also be used in the case of a single person. That they can also be used to basically convert a single person's excess assets into an income stream. That income is going to be ultimately paid to the facility, but because they're getting a lower MassHealth rate, sometimes it does still make sense for the single individual to use an annuity versus just a traditional spend down. All right, so another option for crisis planning are these pooled trusts that we addressed previously. So this can be a good option for a single individual that doesn't have a spouse at home that can receive the assets and do an annuity or something like that. So for a single individual, if they have more than the $2,000 asset limit, they can contribute those excess assets to a pooled trust. The funds will be managed by that nonprofit organization. the assets in the trust are not considered accountable resource, and there's no 5-year look back for these transfers to a pooled trust. The pool trust will, they can pay for things that MassHealth doesn't cover. So, private aids, the cost for a private room, clothing, a new iPad, things like that, the pool trust can pay for things for that individual. You can't make gifts to other individuals. But one of the elements of these trusts is that it must have a Medicaid payback provision in it. So when the beneficiary dies, the state can recoup the balance of the funds in that trust. So it's not a great way to, try to preserve assets for future generations or anything like that. It's really just meant to preserve assets for the MassHealth applicant, while they're in the nursing facility, to have them have additional assets to supplement their care. All right, so I'm going to do an example here. Just to illustrate how some of these planning options work. So in this example, we have John. He's 82 and he is in a rehab facility following a hospitalization. And it has been determined that he needs to stay in long-term care. So he has a wife, Linda. She lives at home independently. She's 80. Between the two of them, they have around $500,000 in assets. They have a primary home that's worth about $750,000, and they also have joint checking accounts. So what are we going to do here? So the first thing we want to do is move assets into Linda's individual name. Because we need to have, John's assets need to be below the $2,000 amount. Once the assets are in Linda's name, she can purchase a Medicaid compliant annuity with the assets that are exceeding the spousal allowance. So we can leave some assets in her individual name. We usually want to spend down to below the community spousal allowance, just so there's a little bit of cushion during the application process. So let's say we spend down to, she keeps $140,000 in her individual name, and the additional assets are used to purchase this Medicaid compliant annuity. So what that means is that the excess assets are now become an income stream for Linda. And so let's say that this annuity has a 6-year term. So over the next 6 years, Linda will receive monthly distributions from that annuity. And those monthly distributions are not going to impact John's eligibility for MassHealth, because MassHealth doesn't care about the spouse's income. In conjunction with this, we're going to recommend that Linda create a new will with a testamentary trust for John. And this is because if something does happen to Linda, if she were to pass away first, we don't want the house and any assets in her name to go back into John's name and make him ineligible for the MassHealth benefits that he's going to be receiving. So if she creates this will with a testamentary trust, it's ensured that those assets that are in Linda's individual name will be, preserved for John's benefit. They can be used for him while he's living. And then upon, when both of them have passed away, those assets, they're not subject to any type of estate recovery claim or lien, so long as Linda, did not later go on benefits herself. So with this type of planning, John would become eligible for MassHealth benefits as of the date that the annuity is purchased. And the way the MassHealth application works is you can submit the application within 3 months from that eligibility date. And once the application kind of works its way through the agency, benefits can go retroactive to that original eligibility date. So that is a big question that comes up a lot, is, well, what do we do during the 5 or 6 months that the application is pending? And the facilities, if they know the Medicaid application is pending, they may still send you invoices to reflect the amount, but they shouldn't be actively billing if they know that Medicaid is pending. And ultimately, if the person's eligible and the application is approved, the MassHealth benefits will go back and pay those prior months. So, but what if John doesn't have a spouse at home? So what if this is a situation where John is a single person? So I think one of the best options here would be for John to contribute his excess assets to a pooled trust. The house can remain in his name, but it's not a countable asset, but it is going to be subject to a Medicaid lien upon his passing. Because a house in his individual name is a probate asset, and that's something that will be subject to that lien and an estate recovery claim. If he has a child who was living at home and providing care, if he has a sibling who had equity interests in the property, or if he has a disabled child, then would want to look at options to transfer the house to protect the house as well. Um, but otherwise, as soon as his excess funds are transferred to the pooled trust, that's when he's going to be eligible for MassHealth and can submit an application. So there's other, depending on the amount of resources, when we're doing this type of spend down, we probably also want to do a prepaid funeral plan, kind of use other spend down options to set things up for the future. And then, once the pool trust is established, it can be used to pay for things for John's benefit while he's living. As I mentioned, it does have that Medicaid payback. So, MassHealth may have a claim against it, but he can designate, children or other family members or other individuals as beneficiaries if there are funds remaining after the MassHealth claim. So the way the MassHealth application works, one is that it does take a long time, typically. So once the individual is in the facility and has become financially eligible for MassHealth, an application will be submitted. Once the application is submitted, usually MassHealth comes back and requests a lot of additional information. And as you know, MassHealth can look back 5 years and request bank statements and things like that. So there's a lot of documentation that has to be gathered and submitted to MassHealth as part of this application. So, once these requests for information go out, they generally give you a period of time to respond to them, to gather any additional information. And generally, if you're, responding to these information requests and submitting the information, then the original application date that you applied for will be honored. And as I mentioned, coverage is retroactive, so there's not going to be a period of time where there's a gap in coverage. If you are going through this process and receive an adverse decision, so sometimes it could be, a denial because they didn't receive the information they requested in time, or it could be denied because they're counting some asset that you think is non-countable, or if there's some other, reason for it to deny benefits that you disagree with, you have up to 60 days to request a fair hearing with the Board of Hearings. The hearing can be in person, it can be remote, and hearing officers typically have more discretion than the MassHealth caseworkers. So some of these exceptions that we discussed, appealing for an increase in the spousal allowance and things like that, those can only be resolved through a MassHealth appeal and a fair hearing, because the caseworker is not going to have the authority to approve some of those, exceptions. And beyond that, if you have a fair hearing and are still denied, there is recourse under state law. You can appeal to the Superior Court for further review. So there's quite a bit of due process involved in these MassHealth applications and appeals. So I know that was quite a bit of information, and I apologize for my voice throughout. I think I'm having some allergy issues. But I do want to open it up to additional questions.
So, Laura, there's a bunch in here that I'm just going to send over to you. We did that. And thank you so much for the presentation.
Oh, sure. So, okay. All right, so so I have a question here. It says, are cash gifts to family members allowed? Typically, no. So a cash gift to a family member is going to be, that's considered a transfer of assets for less than market value. So that's something that is going to be subject to the penalty period. I guess some exceptions to that. Whenever you ask a lawyer a question, the answer is it depends. But the exceptions to that would be obviously if you give cash gift to a spouse, that's not a transfer because it's your spouse. If it's a disabled child or other, that's not going to be considered a gift. But and also, I mean, if it's a $50 birthday gift or something like that, MassHealth typically isn't looking back and saying, oh, you gave $50 to your granddaughter last year. They're not going to penalize something like that. But if you gave a granddaughter $15,000 to help pay for her wedding, that could be something that MassHealth is going to penalize and needs to be addressed. Let's see. It's a lot of okay.
Sorry.
Questions. Oh, that's okay. Question here, after death, can MassHealth take any remaining assets? So that is the estate recovery process that we are going to go into more detail on, I think next month in May. But generally speaking, yes. If you are receiving MassHealth benefits and you pass away, if you have assets in your individual name, MassHealth can pursue an estate recovery claim against your estate. And that could include real estate if you know your primary residence is still in your individual name. Okay. How is MassHealth Planning coordinated with veterans benefits? That's a good question. So we didn't address veterans benefits in here. If you or a parent or loved one is a veteran and has qualifying service, there are certain benefits available. There's something called aid in attendance, which can provide assistance with paying for assisted living or care at home. There are long-term care placements available through VA agencies or facilities. I wouldn't say it necessarily coordinates with veterans benefits. That's always something we're looking at when we're addressing long-term care planning. We want to know if the individual or their spouse qualifies for veterans benefits, because that could provide some additional support as well. There's a question here. It says, when would one do the MassHealth annuity versus the pooled trust? So again, it depends, but typically the MassHealth annuity option, or that Medicaid compliant annuity, that could be a really good option when there's a spouse, because what you can do is shift assets into the spouse's name, and then the spouse can purchase the annuity. And then as the annuity funds are returned to the spouse, they can keep them in their name, and it's not going to impact the other person's benefits. So that is a good planning option in those circumstances. The pooled trust is usually more appropriate when there's not a spouse that can purchase that annuity, because then you're limited to that $2,000 asset limit just for the individual person. And so, the pool trust can be a good way to set aside some funds, not spend down everything, and still have some funds available for the person needing care. Oh, is it possible to share the average cost range for setting up an irrevocable trust? Sure. I mean, I can only speak from our perspective, but usually around 5,000 to 7,000 is a average range. But again, it depends on the complexity, what types of assets are going into it. If there's multiple assets going into the trust. So that's just an estimate. Oh, this is a good question. Can a house be sold and another bought with the funds? So I think what this is referring to is if you transfer your house into an irrevocable trust, can the house be sold and then purchase another house, maybe downsize and get a condo? Yes. So within, if it's a properly drafted irrevocable trust, Whoever you have designated as the trustee of that trust can sell the house and can purchase a new property with the proceeds from that first sale. If there are excess assets, so if you have a $700,000 house that you sell and then you buy a $500,000 condo and you have some excess proceeds, those would stay in the trust. So those can't be distributed out to the parent. I keep saying parent, but those can't be distributed out to the person who created the trust, because that would violate the trust terms. All right, I'm just trying to see what I already answered. I haven't been marking them. So there's a question here. Can you explain the step up in tax basis upon death? Yeah, I didn't do a great job of explaining that. So I'm going to give the example of real estate, but let's say parents bought their house in the 70s for, $80,000, whatever they were able to purchase their house for back then. And now it's worth, $1 million. So the parents' tax basis in the property, if they were to sell it while they're living, is that purchase price of $80,000, plus they can add in, if they did a new kitchen or put the roof on, they can add in improvements they made to bring up the tax basis. When the parents, so if the parents then sell the house now while they're living, they're going to have significant capital gains, and they can get an exemption, the residential exemption up to $250,000 per spouse, but there still may be, significant capital gains they would have to pay on that. If the parents pass away while they still own the house and their children inherit it, the tax basis of the property is stepped up to the value as of the parent's death. So if the children then sell the property, there wouldn't be capital gains, because that's the tax basis is what it's worth now. So if we're putting the house in trust, we want to make sure that we're preserving that step up in the tax basis. So if the house is in the irrevocable trust and both parents pass away, the children inherit it through the trust, they're going to get that beneficial tax basis at that time. So it's just important that if you are using an irrevocable trust for real estate, that there's provisions in there that would allow that step up in basis.
All right, Laura, I think we're about to run out of time here. So I know I did answer this globally by writing it, but we did record the presentation. We will not have the slides available, but we will have the recording of the presentation available. It usually takes about a week for us to process and get it on the website. It will be on the website. It'll also go out on our e-letter if you are subscribed to our e-letter. So with that, I think super grateful, Laura, for everything, and very informative. And I think you're coming back from for one of the other sessions.
Oh, good. Okay.
And then the other option, hopefully everybody saw this, is I know it is easy to do this online, but if you are in the area and want to come to one of the lunch and learns, we are going to be doing that in our office. And the one that is on this, it's the same topic, will be the Introduction to MassHealth Planning, is going to be April 28th at 12 p.m. At our building. So you should have that information as well. I'm assuming you got through when you registered for this. So, but if you have any questions, you can reach out to Laura or myself. And we are grateful for everyone taking the time today, especially on this beautiful day. So if you have time, get outside. Thank you.
Thanks, everyone.
Thanks. Bye.